Welcome back to More Law on Fox 19, your legal questions live, with local broadcaster and award-winning reporter Deb Haas and Cincinnati personal injury attorney Don Moore, recognized by Ohio Super Lawyers. More answers, more help, more law on Fox 19.
We're back talking about DUI today on More Law, but before we take another call, we'll go to Dan Moore in the More Law Connection answering viewer emails. Dan?
Hey Deb, how you doing?
Very good. Yourself?
Pretty good. Happy New Year to you.
To you. Thank you.
Today our first question is from Edna. She wants to know, I went to the ER last week for a broken ankle and got a staph infection. Can I sue the hospital for making me sick? Okay, there are really, whenever you enter to a medical institution, whether it be a hospital, a nursing home, an urgent care, you have a chance of acquiring an infection. And legally speaking, I think there are two causes for an infection to occur. One is because somebody did something wrong. They failed to sanitize an instrument. They failed to wash their hands. That's negligent, and that could cause an infection. But by far, the most common cause of an infection is it's just a risk of the procedure. It's a risk of going into the hospital, into that nursing home. There's lots of diseases floating around there. You can pick something up while you're there. It's just a risk. And if that's the case, and the doctor tending to your ankle did everything he or she was supposed to do to protect against an infection, and the infection still occurs, you don't have a case, rather. If, on the other hand, you're able to prove that the doctor didn't wash his hands or use something that was dirty, or the hospital did something that didn't protect against an infection, then you might have a case. But again, by far the vast majority of time, it's just a risk of being in one of those institutions. Deb?
All right, Dan, thanks a lot. We are back again with Nick Klingensmith, our guest. Thank you for being here.
Thanks again.
People are looking for a lot of information today. We are talking about DUI. Let's head back to the phones. First up, Cliff in Milford. Cliff, I understand you have a question about blood test versus breath test.
Yes, ma'am.
Please, can you go ahead? I'm not sure exactly whether to take one or the other. What are you asking us?
Well, my question is, if you refuse the breath test and they take you to jail, will they administer a blood test, or is it legal for them to do so?
We were just talking about that during the commercial break. Can they do that?
Generally what happens when you refuse a breath test, besides some exceptions, there are exceptions to every law, is that'll be the end of it. They're going to probably let you call someone to come pick you up from the police station. Very rarely does anyone actually go to jail the same night after being arrested for a DUI. So once you say no to the breath test, that's pretty much the end of it.
But then how would they end up charging you with a DUI?
Well, there's different ways they can charge a DUI, but at that point, the police officer already believes that you've been operating a vehicle while under the influence, and he's going to go ahead and write you that ticket and charge you with the OVI.
Okay.
So whether you get convicted of the DUI or not, you still got consequences for refusing the breath test, right?
That is correct.
And what are they?
If you refuse the breath test, you're going to lose your license automatically for a year, and also you cannot get privileges for the first 30 days of that suspension.
Okay, and when you say privileges, just so it's clear, what does that mean?
To and from work, to be able to get back and forth. If you're in school, to get back and forth from school. And there's some other privileges that judges may grant.
Okay, so it's clear, if you refuse a breath test, whether you're convicted of DUI later or not, you're automatically going to lose your license totally for 30 days minimum, and for a year as far as pleasure driving for sure.
That's correct, but there are exceptions to that and ways around it.
And that's where getting a lawyer that knows the ways around it comes in.
Definitely, definitely.
All right.
Okay. Let's head to Carl in Lebanon. Carl, you had a question about refusing a breath test, right?
Yes.
Go ahead. I'm sorry, I didn't understand the whole question.
Okay, well, I heard that there's a law out that they can physically charge you with a crime for refusing any field sobriety and or breathalyzer.
Well, that's two separate things. There is no penalty for refusing to do the field sobriety test. You're free to say no to those. However, if you refuse to take the breath test, we were talking earlier about the look-back period. If you have a prior DUI conviction in the last 20 years and you refuse the breath test, it is actually a separate charge. Again, the law is written very confusing, and there's a lot to it and a lot of different ins and outs. But yes, there is a separate charge for refusing a breath test if you have a prior conviction for DUI.
But there's never a charge for refusing to take the finger to nose or the walking or all those other tests. You don't have to do them at all.
That's correct.
And there is a difference between taking a breath test on the scene, the little portable thing they carry around with them, versus back at the station. Is that right?
That's also correct. If they ask you to blow into the portable breath test roadside, as we call it, or at the scene or on the street, there is no consequence for refusing to take that test. In fact, most courts will not even take the result of that test into evidence.
Okay. All right, let's head back to Dan now with another email question. Dan?
All right, thanks, Deb. Our next question is from Roy. He says, my son is graduating from high school in the spring. Do I still owe child support when he goes to college? The answer to this is actually pretty clear in the law. There are really two ways that set the time period within which you have to pay child support. If you have an agreement and you agree to pay child support, for example, in perhaps a divorce settlement, you agree to pay up until the kid gets out of college, or you agree to pay until the kid gets 20 years old, or whatever the agreement is, that would govern. Now, the law, if you don't have an agreement, the law sets a time period, and that's 18 years old or until the kid graduates. Now, if the kid takes an extra long time to graduate, and he doesn't graduate until he's after the age of 19 or he's 20 or something like that, then it cuts off at 19. So you have an agreement or you have the law, and whichever your situation dictates will govern there. Okay, if you have a question, go to the fox19.com website, click on the More Law button at the top of the page, fill out to send us your question form, and of course send it in, and we'll do our best to answer as always. That is all I have for today. Deb, have a happy new year, and don't get in any trouble tonight.
Oh, I'll do my best. Thank you for looking out for me, Dan. It doesn't sound like any fun, though. But we will be right back here on More Law talking about DUI. Give us a call, 513-421-4691. The Ohio and Indiana Bar Associations require we give the addresses of the attorneys on the show, so there you go on your air right now. Nick Klingensmith, you can find him at klingensmithlaw.com. Don Moore and Dan Moore at the Moore Law Firm, morelaw.com. All of that information, though, fox19.com, and click on More Law. Today, of course, we are talking about DUI, and there's some really important information that you felt the viewers should have.
Yeah, actually a couple of things. And one of the things that I would encourage them to do is to take a look at Fox 19 and go to the More Law website, because two things. Number one, if you've missed a show that you're interested in, you can go back and see it. Two, we're going to show you a graphic in just a moment here. And basically, this is to help you understand how many drinks it takes to get you over the legal limit. And one of the things that was terribly disappointing to me recently, I was doing depositions in a case that is taking under oath, questioning bartenders about what they knew and how they were trained and how they were taught. None of them were familiar with this graphic that we've got in front of you right now, and you can go on our website and we'll have a link to that. And basically what it says is you're going to get about 0.02 per 12-ounce beer or 1 ounce drink of alcohol. In other words, if it's a mixed drink, one shot. You're going to get about 0.02 for the average person. Varies depending on your body weight, varies depending on male or female, but 0.02 per drink per hour. So basically to get to 0.08, you got to drink 4 drinks inside of an hour. It accumulates though. You lose some, you'll lose 0.02 generally about per hour, but it'll continue to accumulate as long as you're greater than that. That's a big deal, and a lot of bartenders don't know it. In our case, we had a person that was intoxicated well above, more than double the legal limit. They went out and they were killed in a fatal accident. They killed themselves, and unfortunately they hit my client, who was an innocent, and permanently disabled them. So it's a big, big deal. And for a bartender not to know, and the average person not to know, there's no law against drinking and then driving. There's a big law, a big important law against driving while impaired or being above the legal limit. So if you don't have any idea what it takes to get you to the legal limit, how are you supposed to know?
Right. And you know, we have a caller who has a question that's very similar on more of a personal level than a professional bartender. But Judy and Trenton, you had a question about the consequences for you as a party host, right? If your guests have had too much to drink?
Exactly. As a bartender, I was just really concerned with what could happen to me if somebody does get out there and something happens to them and I am the one that served them.
Mm-hmm.
Well, and basically you can be on the dime. And there are the dram shop law is the one that applies to professional bartenders. And basically in the dram shop law, what it says is that if you negligently allow a person to become intoxicated and they're hurt or they hurt someone else on the premises, that the establishment and the bartender that served them can be liable. It gets a little trickier if they're off the premises. That would be like they leave the parking lot, and like the accident I talked about where we had a client permanently disabled as a result of a drunk driver. In that case, the bartender has to have served a person who was noticeably intoxicated. And so that means that their actions, all the things we talk about, slurring, staggering, change in the rapidity of their speech, their voice volume, loss of inhibitions, they're singing, they're whooping it up, all signs that as a professional bartender you probably recognize. The sad thing is, at least when I was taking the depositions of these bartenders, most of them hadn't been trained. Some of them had no training, some of them had a little bit of training. None of them were familiar with the blood alcohol table that we just showed on the air a few minutes ago. So that's really sad. But you can be liable as the actual bartender doing the serving, as can the institution that serves you, under that dram shop law I just discussed.
But Don, what about a homeowner? You know, there will be a lot of people tonight having New Year's Eve parties at their homes,
Yep.
and people will be there and they will be drinking, and then they will be leaving. Who's responsible if something happens?
Well, that's a really good question, and for a social host, it's pretty clear in the state of Ohio. The social host has no responsibility for an adult that they serve, period. The drinker, the person who actually drank the drinks, they're the only one that's responsible. Two, if you serve minors as a social host, now you're on the dime. If you serve kids, 16, 17-year-olds, stuff like that, and they go out and hurt somebody, not only is the kid responsible and their insurance, but also the person who gave them the booze.
Okay, great. And we just had about a minute left, Nick, but you wanted to be clear to folks that there's really, on a night like this, they do have some recourse. I mean, certainly we can all leave a car in a parking lot and get a cab, but there's some extra help out there for folks tonight.
Actually, tonight and I believe tomorrow, there are free cab rides through AAA and I believe also MAD, the MAD organization. But if you call, I don't have the number off the top of my head, but if you look online, there's actually free cab rides tonight. So tonight of all nights, there's absolutely no excuse to drive while intoxicated.
Okay. Thanks so much for joining us today.
Yeah, thanks a lot, Nick. Great to have you.
Thank you very, very much.
You have a good week yourself.
And you as well. I understand next week we're doing how to purchase car insurance.
Well, we'll be looking forward to that. It'll be how to purchase car insurance, then all about injuries the following week, divorce and child custody the week after that. Meantime, have a great week, and we'll see you Monday morning at 9:30.